Hear ye, hear ye. The Supreme Court of the state of Wisconsin is now in session. Your silence is commanded.
Please be seated. Before we call our first case, the court wants to take a moment to recognize Justice Crooks' passing yesterday. He was, to the state, an outstanding legal scholar and a dedicated public servant, and to the court, a dear friend and colleague with whom it was a joy every day to work. So he will be greatly missed. And at this time, I'd like you all to take a moment of silence to honor Justice Crooks. Thank you all. We will proceed as Justice Crooks would have wanted us to do. He worked very hard to be with us whenever he could be. You will notice, of course, that there's his chair absent and the chair next to him is absent. Justice Ziegler is not participating in this case, so it will be the 5 justices who are on the court who will be hearing this matter today and who are participating.
I would like to read one of Justice's last writings. People are always asked, what's your legacy? And legacies are ordinarily in the writing, and this is what Justice Crooks wrote. The United States Supreme Court, and the reason I'm reading it is because this is his view of what a justice is. The United States Supreme Court has recently acknowledged that judges are not politicians even when they come to the bench by way of the ballot. Williams-Yulee, which is a case he referred to, involved whether a judicial conduct rule prohibiting judicial candidates from personally soliciting funds violated the First Amendment. In concluding that the First Amendment permits the particular regulation of speech, the United States Supreme Court stressed, quote, in deciding cases, a judge is not to follow the preferences of his supporters or provide any special consideration to his campaign donors. A judge instead must observe the utmost fairness, striving to be perfectly and completely independent, with nothing to influence or control him but God and his conscience. These principles, wrote Justice Crooks, must serve as guideposts for all of us as judges to the courts of Wisconsin, whether or not the case or cases at issue involve significant political, and I would add, economic overtones. That's what he wrote. That's what he lived by. That's why we're here.
We will call now the case for today, Wisconsin Pharmacal Corporation, case number 13-0613 and 13-0678. Counsel, are you prepared to proceed?
Yes, Your Honor.
Okay, let's see what the lineup is here today. Okay, so I have 12 and a half minutes for Attorney Shrimp and 12 and a half minutes for Attorney Wolf. 15 minutes for Attorney Raines, 15 minutes for Attorney Silver, and a rebuttal by Mr. Shrimp. Is that correct? Okay, please proceed.
You know, it's a little unusual that we do business as usual, however, the morning after our colleague's death. But we do this really in testament to his legacy, knowing that he would have wanted it this way. So although many of us are find it difficult, it's in his honor that we proceed. So, how's that?
Please
for
proceed,
introduction?
counsel.
May it please the court, my name is Tom Shrimp. I represent the defendant, respondent, petitioner, Netherlands Insurance Company. First, I'd like to start off on behalf of all counsel for thanking the court for entertaining the argument today. What has to be a very difficult day for all of you. The loss of Judge Crooks.
I think you'll have to raise your podium and speak more directly into the microphone.
Our
please.
sound system here is not good, so it's not your fault, Counselor. We're having it replaced in December. We hoped we could do it this summer. It just wasn't possible to do, but it's kind of hard, so you have to try to be sure the microphone has a good proximity to your mouth when you talk.
As Governor Thompson said, he spent $50 million redoing the Capitol, and the sound system doesn't work.
Please proceed.
Sure. I'm certain it's very difficult to proceed today. I'd like to express my sympathy. The loss of Judge Crooks is a loss not only to the court, but to the people of the state of Wisconsin. To give you a brief outline, there's 3 coverage issues raised under the CGL policies issued by Netherlands Insurance Company and Evanston Insurance Company. The first is whether the supply of an ingredient that causes a recall of product incorporating the contractually non-conforming ingredient is a claim for property damage, as that term is defined under the policy. The second issue, does an action that alleges purely contract-based claims seeking purely economic damages as a result of contractually non-conforming goods constitute an occurrence? And the third issue is, do the business risk exclusions apply to exclude coverage if there's coverage under the insuring agreement? So the court knows I will be addressing primarily the first issue, whether there's property damage. Okay. Attorney Wolf will be arguing issues 2 and 3.
Is there any real difference between the two of you of where you think this court should go? The way I read your briefs, you may state the cases a little differently or not, but essentially you're in agreement.
Yes, we're almost 100% in agreement, Your Honor.
All right. You're fungible then, at the moment, okay. All right, can I just ask you one question before you begin? This policy says that you're liable for whatever your insured is liable, or words to that effect. You know the language I'm talking about? I hope I can find it quickly. And so you accept, or let's say this way, the insured has damages here, right?
Well,
Of one sort or other. You just don't think you're obliged to cover them.
That's
right?
correct.
And what kind of damages are we talking about? I'm not talking about dollars. I'm talking about the nature of the damage.
The nature of the damage is the economic loss.
Well, that's your doctrine. I want to know, what is it? What's it
Sure.
that, how much it took to recall, which raises another issue, or did they have to pay the retailer any money? Did they have to pay the ingredients in the tablets any money? That's what I'm talking about.
What the plaintiff is seeking in terms of recovery is, first of all, the recall costs of the product.
Okay.
Number 2, the value of the manufactured product that, because of the recall, could no longer be sold in the marketplace. And they're also seeking lost profits that they claim may have resulted because they lost their contract to sell the product to the marketplace.
Okay, that's what I was looking for.
Okay.
All right, so they did incur damages. There's no question about that. The question is whether it's property damage or There was an occurrence.
That's correct,
Okay,
Your Honor.
thank you.
And the facts here are really not in dispute. Netherlands insured Jeneil Biotech entered into a contract with Evanston's insured Nebraska to supply a probiotic bacteria named rhamnosus. Nebraska in turn sold this product to Nutritional Services. Nutritional Services incorporated the bacteria with other ingredients into a chewable probiotic tablet for Wisconsin Pharmacal, which is the plaintiff in this case seeking the damages. Wisconsin Pharmacal then turned around and sold the probiotic tablets to a retailer for sale to the public. Eventually it was discovered that the tablets did not contain the rhamnosus, but a different probiotic bacteria, Acidophilus. And as a result, the product was no longer marketable and the product was recalled. Wisconsin Pharmacal then commenced this lawsuit to recover their economic damages it sustained as a result of Jeneil and Nebraska supplying the wrong bacteria. As the case proceeded, Netherlands and Evanston moved to bifurcate and stay the merits action in order to address the coverage issues that are now before this court. I think as the court understands, under the insuring agreement, in order for coverage to exist, a claim must seek damages because of property damage caused by an occurrence. The issue here is property damage, which is a defined term in the policy, is defined as physical injury or destruction of tangible property, or a loss of use of tangible property that has not been injured or destroyed. The issue here is whether the incorporation of a non-conforming ingredient into a product qualifies as property damage under either prong of the property damage definition.
Can it come under both clauses? Can something come under both clauses, or are they inconsistent?
No, it has to be one or the other.
That's right, because under the first one, it had to be physical injury or destruction of the tangible property. Under the second one, on loss of use, the property could not have been physically injured or destroyed. So if you come under one, you can't come under the other.
That's correct, Your Honor. Now, and just to be complete, under the first prong, if there is physical damage, the definition goes on to state it also covers the loss of use, but just for clarification. We submit that this case is controlled by this court's decision in Wausau Tile. The facts are indistinguishable from Wausau Tile, and as well as the California case, which Evanston relies upon, F&H Holding. The Court of Appeals, without stating, essentially overruled this court's well-reasoned decision in Wausau Tile, finding that there was property damage, that is, physical injury to tangible property, under the facts of this case. But if you look at Tile, there they combine three ingredients: cement, aggregate, and I believe water, to form concrete pavers. Once those were manufactured, those pavers cracked, and Wausau Tile, like Wisconsin Pharmacal in this case, sought from the cement manufacturer Medusa the cost to repair or replace the tiles.
So the essential holding from Wausau Tile that you're relying on is once a defective ingredient is incorporated to make a completed product, those other ingredients that comprise the product can't be property damage. You look at the integrated whole, not the effect of one ingredient on the other in a completed product.
Yes, that is correct, Your Honor.
Let me see if I have this right. That's the integrated systems doctrine of the economic law, component of the economic loss doctrine. It appears to me that your opposing counsel are arguing based on American family and its prodigy, perhaps, that you look at the initial grant of coverage, then you look at the definition, of course, of property damage and occurrence, and then you see if the exclusions apply. You look at the words of the policy and interpret it as a contract, and only get to the economic loss doctrine vis-a-vis a consideration of remedy. How does Wausau Tile comport with that approach or depart from that approach?
Well, Wausau Tile, obviously, a large part of the decision was the economic loss doctrine. And I think Justice Rogensack correctly defined what that meant.
Well, what the holding was, what I'm interested in is the analytical framework. Did Wausau Tile say that there is property damage, there is an occurrence, but they are negated by the economic loss doctrine? Or did they, as you read the opinion, kind of superimpose the economic loss doctrine on the analysis without getting to, like loss of use or...
Wausau Tile actually did both. They superimposed the argument, especially with respect to property damage. And let me demonstrate why. If you look at the facts in American Girl, where you have the negligent act or conduct, in that case was improper soil analysis. As a result, after the building was completed and built, the foundation started to crack and buckle. Obviously, under those circumstances, we have physical injury to tangible property, no doubt about it. But let's just assume for the fact that the improper soil analysis was discovered before there was any physical injury to the building. Under those circumstances, all we essentially have is faulty workmanship. And this court has ruled time and time again that faulty workmanship in and of itself is not property damage. In our case, we have essentially the same thing. We have these tablets that are part of an intentional manufacturing process. There is no physical injury to those tablets. All we essentially have is faulty workmanship. They're non-conforming because the insured supplied the wrong ingredient. But that does not constitute physical injury to tangible property. All we have is essentially a non-conforming product. This court has been very careful in its decisions to make sure that a CGL policy does not become a performance bond. And with respect to the result that's being advocated by the respondents in this case, by the insureds, they want to turn this insurance policy, which is to protect against property damage to third parties, into a performance bond so that the quality of their goods is guaranteed by the insurance policy. That's not the intent of a CGL policy.
How do you distinguish, and I'm asking this question in Justice Crooks' honor, how do you distinguish Wausau Tile and American Girl? You know, he dissented in American Girl. He always was interested whether the dissent would withstand the future or Wausau Tile and would be the future. How do you distinguish Wausau Tile from American Girl?
Well, in two respects. Wausau Tile essentially had the integrated product and was concerned with property damage, whereas American Girl was primarily more concerned with whether there was an occurrence and whether there was a clear line of demarcation between contract claims, solely contract claims, and whether they're covered by a CGL policy based upon the economic loss doctrine, or whether contract claims can also be covered. So that's really the distinguishing factor between those two cases.
Thank you.
Do you think, I have one other question, sorry.
Is there an issue at all about duty to defend?
No, No, there's not. And the reason there is no issue about the duty to defend is that the insurers in this case followed what this court has told us to do on numerous occasions, that is, we moved to bifurcate and stay the underlying action so that the coverage disputes could be resolved before the merits case proceeded.
Thank you very much.
Could I ask another question? I may be repeating things that Justice Bradley has asked you, but if you just looked at your policy, why is loss of use of tangible property that is not physically injured, why isn't that property damage?
Because the claim in this case is, and just going back a little, per the insurance agreement, it's damages because of loss of use of tangible property, if you combine the two definitions. In this case, what they're seeking is damages for loss of property, not damages for loss of use. Damages for loss of use, the prime example is if my car is wrecked in an accident, the damages for the loss of use would be the cost of a rental vehicle while my car is being repaired. Loss of property would be for the value of the wrecked vehicle. And in this case, they are not seeking damages for loss of use of property, they're seeking damages for loss of property.
So the fact that they would sell this property and make a profit, that's not loss of use of the property in your...
That's correct, Your Honor.
Thank you.
Thank you.
Good morning. I too would like to share my sentiments and express my condolences to everyone here at the court. You know, when I look at these issues, I've often said to anyone who will listen to me, and that's very few people in this world, that I'm just a simple Irish guy. And so I look at this case from just a tiny bit of a little different perspective. And I look at it in terms of what is it that this insurance policy is supposed to do? The bigger picture is, as your courts, the Wisconsin courts have explained in detail the purposes of a CGL policy. It's not meant to provide coverage for poor workmanship. It is not meant to provide coverage for failed business expectations.
Can you buy coverage that would cover those losses?
You can buy performance bonds. You can, and even if you can't buy the coverages, these are contract provisions. You have warranties. So if a person gets, the wrong widget when they bought it, they have that per the benefit of their bargain, there is a warranty that is available to them. So there are remedies for this, but it is not a CGL policy. And I think in all the discussion and all the letters of the law here, I think you sort of forget that, and I just kind of want to take a step back and look at that. So with that being said, there is not an occurrence in this particular case. Why? Because there's not an accident. If you read the definition of an occurrence, really the first two words are an accident, including continuous repeated exposure, but it's got to be an accident. Here, the probiotic was made. It was intentionally made that way. It was sold that way. There was an intent to integrate this product. And the mistake was a misrepresentation. The mistake was not an accident. As Judge Riley tried to explain in the underlying appellate court, that every misrepresentation is to some extent volitional. That's the way it is. The state of Wisconsin has said that on a number of occasions in your opinions. It's not an accident for purposes of coverage.
Some of this stuff is so fungible. that even a simple
There's that word again,
Yeah,
fungible.
so that simple Irish attorney can, and a simple Irish justice can understand it too. But, you know, it seems to me that whether it was misrepresentation or whether it is an accident is really outcome determinative terminology. Do you think that, and it depends on where you on the spectrum you want to focus, you can come out either way. Do you think it's that they accidentally put or omitted the important ingredient, or they intentionally omitted it, right?
I think that they made a product. They intentionally made that product. They intentionally sold that product. They sold the wrong product.
Yeah.
It was
Okay,
a
but
misrepresentation.
my question was, do you think they accidentally or intentionally omitted the ingredient? What do you think? Do you think they intentionally omitted that?
I think when they made it, they made that product. The problem, the mistake, was selling it as something else. And that's
then
what we're talking about
the
here.
answer to my question, did they intentionally omit the product, or was it accidentally, or not intentionally omitted? I won't even use the term accident. Was it intentionally omitted or not, or unintentional in its omission?
If you're asking me, did they intentionally sell the wrong product? I'm sure they didn't. That's not
That
that in
wasn't
my
exactly
humble
my
opinion,
question.
isn't the.
And I don't
okay.
need to continue.
No, that's okay.
This, but to make the point is, depends on how you frame the question. It depends on what you want to focus on. You know, did they misrepresent it? In part, sure they did, because it wasn't accurate, you know. Did they intentionally misrepresent it? Who knows? Did they accidentally omit it? Who knows, you know? Your answer and your conclusion in these arguments in part depend on what point in time and what subject you want to focus on. You can turn it both ways. Tell me that you disagree with me on that.
But Judge, I'd never tell you that.
Well, tell me that I can see the light in a different fashion.
You are Irish. Huh?
And I'm fungible because my wife has told me that on many, many occasions.
That isn't the word she used, you misheard her.
Well, I've heard those words as well.
Counsel-
You know, but let me just kind of expand on that thought just a little bit, if we could. You know, in this day and age of integrated products, if we're going to go that detailed, then you're going to get to the point where everything is an occurrence and everything is property damage.
I'd look at the Budrus decision. Judge Griesbach up in Green Bay, you know, he saw it differently than you.
He did. In that case, an occurrence was conceived, and this is a long time ago, that case, in the appellate court, and I'd like to think they didn't have the wisdom of both American Girl and Wausau Tile. But in that case, for whatever reason, the occurrence argument was conceded. And there we had a temporary loss, which goes to the property damage argument, and it was not an integrated product. We live in a little different time from that decision, and I think that it is an important decision, important distinction there.
In my question, I blended two things. Griesbach was the Tweet case up in the Lambeau Field, but he didn't see it the same way you did either, nor did the Budrus decision. So, you know, they focused on something a little differently.
Which makes for a good segue into the exclusions. Let's say, Wolf, the simple Irish guy's wrong. You know what? We still have our business exclusions. And that gets back to the beginning when I was trying to explain the sort of 40,000-foot level that I look at it from. It's a CGL policy. It's not a performance bond. It's not a guarantee for poor workmanship. And look at the exclusions we've cited in this particular case. I guess my time is up. The impaired.
No, it's not. You have 5 minutes to go with the yellow
okay.
light. Red light is
See, I
to
can't
stop.
even read, much less.
That's okay. We'll waive it if you get going too far.
The two business exclusions, the impaired property exclusion and the your product exclusion. I mean, don't they fit this case to a T? I mean, isn't that exactly what happened? Isn't this a failed business expectation? They wanted A, and they got B. Nobody got hurt. It was integrated into a product that was wrong, and they took it off the shelves. There's no coverage for property that's rendered useless or less useful by a company's own work product.
So your position is if somebody took this pill and it hurt her, personal damage to her, or it didn't resolve her issues and she spent a lot of time, money, and effort on this pill, it didn't resolve her issues, it caused her greater harm because she didn't resolve it and take the appropriate medication, then your company would be liable. Is that right?
I'm not-
Or are you never liable?
There wasn't a claim for personal injury in this case.
The point, I understand what you're saying. In terms of an insurance policy, that is the step that gets us to an occurrence. And, okay, that's,
I think that's the step that gets you to personal injury.
but we don't have that here.
I know that. That's why I'm questioning you. I'm asking you, when would it be covered by the
If somebody-
policy? Then my next question is, what kind of property damage in this pill would have come under your policy? Can you
All right,
think of
well, I
anything?
suppose, A, if someone got hurt, we'd be talking about a whole different set of
That's
facts.
personal injury. What about property damage?
So I suppose if the pill, as it was constructed, blew up, burst, corroded, and damaged the shelving that was on or went through the floor or something like that, then you'd get to the point where there was property damage. But again, we don't have that.
Is there an occurrence?
In that case, there'd be an occurrence.
And what's the, an occurrence is an accident. What's the accident?
The accident was the pill blowing up, corroding through the box, and ruining the floor.
Well, that brings me to where Justice Bradley was raising questions, and I'm looking at pages 9 and 10 of your colleague's brief. I think this is the Netherlands brief. And it says, Nebraska and Jeneil intended to sell a product to be blended with additional ingredients and formed into the tablet. The sale was volitional, right? Meaning intentional, right? The fact that the product was misrepresented when in fact, well, the fact it was misrepresented doesn't convert an otherwise volitional act into an accidental occurrence. Well, this still was volitional when they made the pill and sold it. Does that have anything to do with occurrence? Where it blows up?
Where it blows up. If it blows up in Dominic's or Jewel or Trader Joe's, you got
Supermarket,
yeah,
yes.
in a supermarket, then you would have
Even
something
though
that the insurance policy would probably respond to.
Even though it was volitional, okay?
But again, and I guess I'll finish with the your product exclusion, and then I'll sit down. This is an even broader exclusion, and it goes, when you get done listening to me, look at that. Any causal relationship is the wording. I mean, that is a very broad exclusion. And why is that? It's because insurance companies don't want to cover poor workmanship or bad outcomes based on the manufacture of the product. If somebody gets hurt, if somebody blows through a stop sign and hurts somebody, insurance policies cover that. If a machine cuts off somebody's arm, insurance policies respond to that. They are not designed to respond to just something that's not created with regard to commercial expectations.
I'm looking at 21, I think it's in the policy governed by Wisconsin law from Netherlands, 21A and B. And B says that your product also includes warranties and representation. So your product goes beyond the physical item of this capsule, is that correct or not?
I honestly cannot answer that question.
How about the corollary provision in your Evanston policy? Which one is that? Can you answer it with regard to that?
I do not have that at the tip of my fingertips. I am sorry.
Okay, no problem.
It's so clear that there is no property damage in this case and no occurrence. Why do you have all those exclusions?
No, the exclusions are based on if there is occurrence and property damage, then you get to the exclusions. Does that answer your question?
It's a belt and suspender, is that it?
I
You might
suppose-
have property damage, but it might be something that's excluded, so you could look at it.
Right, I
two
mean,
ways.
I guess it falls
Who's
under the
answering the
coverage grant.
questions
It
here?
falls under the coverage grant, but then
Sometimes I-
it's taken away by an exclusion.
Sometimes you do. We
Counsel,
Trade off.
I'm sorry.
I do have one other question and would expect some rebuttal from the other side. Suppose you lose here. Would you describe how the world will be coming to an end? What are the consequences of your losing?
Well, I like the fact that you've gotten it to my level. The world comes to an end. Well, I mean, I think as a commercial insurance company, you're going to go, wow, we basically insure everything. It will really become almost like a performance bond, like in a construction site, where you can go out and buy a bond to make sure you do it right. In this case, pretty much anything that happens, even if it's just by a poor result or a less than an expectation that wasn't met, suddenly you're insured for that. That's really not what they're there for. And what will insurance company do? You know, I'm sure they'd have to go out and, I don't know what they would do, because that's really not the law. And I'm hopeful you would see it that way.
Why won't the insurance company just rewrite the policy and make sure if it doesn't want to cover a case like this, it won't? Now, because one of you cited the restatement of torts on economic harms, restatement third, I went and looked for a law review article, and this one is by Professor Pryor, on the economic loss rule and liability insurance, and she goes through what are the boundaries of the economic loss rule and its conceptual underpinnings, and how do the economic loss rule relate to insurability, namely insurance? And she says, well, it's a little complicated, she says. I knew that. And then she goes to say that the economic loss rule, which is a liability rule, bleeds over into the coverage argument and limits insurance coverage in some of the cases, but that not everyone has accepted that bleeding. And she says that the insurance companies just haven't done a good enough job in writing their policies to take into account the kind of case we're dealing with now. I mean, that's her bottom line in 2000, and I think it was 2006. Here it is, 2015, and you think that companies have done a better job? Have you been able to track the language to see if they've taken into account the restatement plus all the writings on this?
Judge, Justice is not the first person in the world to suggest that insurance policies are in some way, shape, or form fallible. Having said that, their policy has not been policies are not been rewritten, as I understand, to take the specific restatement into effect. you get to the point, I think if you're an insurance company, and I'm not one, but you write the language as best you can, you define the terms, you use the Webster's dictionary if you have to, and you have to trust that the good justices like you will give a reasoned decision on it. And I don't think you can react every time a judge somewhere says, or a plaintiff's attorney or a defense attorney somewhere says, this isn't right, you should rewrite it. They'd be rewriting it 24 hours a day. So that's my response. I thank you very much.
And no matter
for your
how
time.
language may be clear to one person, a fact situation arises that raises a question.
What is it? The hard facts make difficult laws, isn't that what we've been taught since law school, which was 2,000, maybe 3,000 years ago in my case?
Right, well, they were wrong.
Thank you very much.
May it please the court, my name is Doug Rains. I represent Jeneil Biotech. The question in this case is whether there is coverage due to property damage caused by an occurrence. The answer is yes. For starters, the sole remaining claim in this case against Jeneil is for negligence, and CGL policies provide coverage for tort liability.
When you say the sole remaining claim was for negligence, I thought the negligence causes of actions had been dismissed, so help me on that.
There is, if you look at Record 21, that's Nebraska's cross-claim against Jeneil. Pages 10 to 11 asserts a claim for negligence against Jeneil. That claim remains in this case, and that's the sole link of Jeneil's presence in this case. There's no claim by the plaintiffs against Jeneil.
Not for breach of contract, just for negligence.
Correct.
Just a cross-claim.
Correct.
Okay, got it.
And the misrepresentation is out.
Correct. That was dismissed.
That's right. So, which could have been intentional or negligent or strict liability, but that's out. So the only claim is the Nebraska cross claim for negligence.
Cross-claim for negligence seeks contribution, and CGL policies are designed to provide coverage for tort liability. And to address Justice Abramson's question to my colleague earlier about property damage, respectfully, what the insurers are arguing is inconsistent with the undisputed record evidence. There's property damage here in the form of physical injury to tangible property to two categories of products. The first is the other ingredients in the probiotic tablet. The undisputed record evidence is that the other ingredients was blended with the acidophilus into an adulterated condition, such that none of the ingredients can be removed or extracted. And the Court of Appeals determined that that caused a change in appearance or material dimension of the ingredients, which is property damage.
You know, counsel, that brings up a question that I had on my mind when I was preparing for this case, and that is that the product, as it was produced, was destroyed after the mix-up, or so to speak, was discovered, right?
I don't think the product was destroyed. It was packaged and then sent to Pharmacal, who sent it to a retailer.
Yeah, but once the retailer discovered that they had acidophilus and not what they wanted, eventually the supplier took it back and they destroyed all of the supplements.
That's my understanding, and that gets to the second.
Does the record disclose why the product, and if it's not in the record, and from my questioning, it doesn't seem that you know anyway. If it's not in the record, then don't tell me. But does the record disclose why the product could not have been repackaged or marketed as containing acidophilus instead of the bacteria that they wanted?
The record does not disclose the reason why that occurred.
Okay.
The record evidence is, and this gets to the second category of product that incurred physical injury, the packaging and the tooling and dyes associated with the product incurred physical injury.
You can't say that that was a direct result of the wrong bacteria. That was the result of of it being sent back to the supplier, and the supplier saying, for whatever reason, I'm going to make the determination it needs to be destroyed. The incorrect bacteria itself did not cause the destruction to the packaging, right?
That's not what the undisputed record evidence indicates. The interrogatory question
I'll
was...
be interested in hearing how the bacteria destroyed the packaging.
Well, I can't say that it did, but I can't say that it didn't. The undisputed record evidence, and this is response to interrogatory number 5, supplemental appendix 052, is that the packaging and tooling and dyes incurred physical injury here. Now, we don't know how that happened, but if there's some skepticism by the court or some skepticism by the insurance companies about how that occurred, it would have been incumbent upon the insurance companies to engage in further investigation here. The fact that they decided to proceed with their motions for summary judgment after discovery took place and after those interrogatory responses were disclosed means self-evidently that they didn't have a dispute of fact with respect to those answers. And so we're left with, again, the undisputed record evidence is that the ingredients in the packaging, tooling, and dyes incurred physical injury. There's also an occurrence here, and this goes to Justice Bradley's question about whether it was accidental. The accidental provision of the wrong product and the use of that product is the occurrence here. And there's no evidence, and the Court of Appeals commented on this, there's no evidence that there was an intent to supply the wrong product. This is paragraphs 26 and 27 of the Court of Appeals decision. The Boudreaux's holding is still sound, and that's an older case, but it hasn't been overruled. And the underlying premise of it is still sound, that the accidental provision of the wrong product can constitute an occurrence. That's exactly what happened here. The court should follow Boudreaux's in that respect.
And it's not relevant that their volition was to manufacture a product and that they intentionally manufactured a product and that they intentionally sold the product. That isn't what negligence means, because the driver intentionally drives 90 miles an hour, but if he's sued for damages, it's an accident. That is, it is a negligent tort of action because he didn't intend the damage, he intended the act. And that's what I hear you saying, that they didn't intend damage here, and that's what makes using the wrong ingredient accidental.
Justice Abramson, I agree with you 100%.
Counselor,
I thought that's what you were saying.
Yes,
I agree with you.
are you familiar with Glending's Limestone, written by Justice Bergeron in the Court of Appeals? Because it speaks about whether faulty workmanship is an occurrence. And she makes a distinction. She says faulty workmanship can cause an occurrence, but faulty workmanship in and of itself is not an occurrence. Can you tell me why I shouldn't be persuaded by that reasoning?
Sure, I think that is correct, that faulty workmanship is not an occurrence. But what we have here is not faulty workmanship. The provision of the product is not faulty workmanship. Workmanship connotes applying a skill to manufacture something, to build something. I looked up the word workmanship in Webster's Third International Dictionary. That's what it says. It talks about manufacturing. That did not occur here. Presumably what happened was the wrong product was selected out of inventory. That's not workmanship, nor is the mere provision of the product. That was an accident. Providing the wrong product was an accident. So even though volitional conduct took place, as Justice Abramson noted, what was the accident was the provision of the incorrect product. That's an occurrence, and under Boudreaux's, that's an occurrence. And that dovetails a bit into the exclusion here. The exclusion only applies if there's no physical injury to tangible property. So the exclusion, the impaired property exclusion, which is the only exclusion that the Netherlands raises, cannot apply here because there's physical injury to tangible property. And again, that goes back to the undisputed record evidence. If the court looks at supplemental appendix 051 and 052, response to interrogatory number 4, and response to interrogatory number 5, both of those indicate that, again, the other ingredients incurred physical injury and the packaging and tooling and dyes incurred physical injury. Now, I want to address for a moment Justice Bradley's question about the distinction between Wausau Tile and American Girl and whether the analysis of the economic loss doctrine governs the coverage analysis. It does not. The economic loss doctrine does not govern the coverage analysis. And that's been held by this court at least twice. The American Girl case, and I'll reference paragraphs 35 and 36 of that case, and also 1325 North Van Buren, and in particular paragraph 59 of that case.
Counselor, when American Girl came down, I joined Justice Crooks's dissent and he mine, because prior to that time, it was my understanding that a CGL policy didn't cover contract damages. American Girl changed that and has been relied on in a repetitive basis, that just because it's contract that's a problem here, it doesn't mean that a CGL policy doesn't cover it. I find American Girl very different from Wausau Tile. Wausau Tile to me is the integrated product case. And that case says that if you have something that's integrated into a completed product, you don't look at the other ingredients of the product to determine property damage. So do you want to speak to that a little bit, please?
Yes, that is within the context of the economic loss doctrine, and I'm glad you raised that point, Chief Justice.
Back you up just a minute so we're on the same page. Wausau Tile talked about the economic loss doctrine, and it grounded the fact there was no damages because of the integrated product theory. But the integrated product theory is an independent theory of economic loss doctrine. I mean, it's been raised in other insurance contexts where people aren't talking about the remedy of whether you get economic losses or not.
The response is property that does not constitute other property within the meaning of the economic loss doctrine because it's part of an integrated product still can be third-party property within the meaning of a CGL policy. And I'll raise two examples to illustrate this point. If you compare the Linden versus Cascade Stone case from 2005 and the Jacob versus Russo Builders case, the Court of Appeals, 1999, both of them involve the construction of a new home and had similar facts. In Linden, there was defective stucco put on the outside of the house. The defective stucco caused water to infiltrate, and the water infiltrating to the interior of the home caused damage to the interior of the home. This court concluded or held that a new home is an integrated product, and therefore the damage to the inside of the home did not constitute damage to other property within the meaning of the economic loss doctrine. You juxtapose that with Jacob versus Russo Builders. Similar facts, construction of a new home. This time the defective product was the masonry on the outside of the home, but the result was the same. The defective masonry caused water to infiltrate. The water that infiltrated caused damage to the interior of the home, the dining room floor, and the court held that the damage to the interior of the home was property damage, damage to third-party property within the meaning of a CGL policy. So again, it's the interior of the home was not other property within the meaning of the economic loss doctrine in Linden because a home is an integrated product. But the damage to the interior of the home under a CGL policy, that's third-party property. So again, and I think you were right in saying that American Girl refined the analysis here. And that is that the terms of the policy govern and not the remedies doctrine. There can still be a tort, but there just can't lie an action in tort under the economic loss doctrine. And again, that goes back to the claim against Jeneil here. It's for negligence. And CGL policies are designed to provide coverage for tort liability. And just briefly, I want to address Justice Prosser about whether there's an issue of the duty to defend here. I want to emphasize to the court what the insurers have sought review of in this case and what they have not sought review of in this case. There were two holdings in the Court of Appeals decision. The first holding was that the insurers owe indemnity to Jeneil and to Nebraska. It was a coverage question. Because we're beyond the four corners of the complaint, we litigated based on coverage. So the first holding was that the insurers owe an indemnity obligation to Jeneil and Nebraska. They sought review of that decision. The second holding, and this is paragraphs 39 to 41 of the Court of Appeals decision, was that the Netherlands owed an obligation to defend under the four corners of the complaint, and that they failed to defend. and Netherlands has not sought review of that decision. So I would submit that regardless of the outcome before this court, that the circuit court will have to determine what the consequence is of the Netherlands' failure to defend in the first instance. So of course we request that the court affirm the Court of Appeals decision, but in the event that it happens not to, there are still proceedings that need to take place between Jeneil and Netherlands to again figure out what the consequences are of the failure to defend under the four corners of the complaint.
I misunderstood. I thought that there was a separation out here, and what the insurance companies were proceeding on was whether there was coverage. If there's no potential coverage, then there's no duty to defend. Is that incorrect?
That's true. I'm saying if the court happens to disagree with our position and reverse the Court of Appeals and hold that there's no coverage, the issue of the duty to defend is still alive between Jeneil and the Netherlands, because the Court of Appeals determined that the Netherlands had an initial duty to defend under the four corners of the complaint and failed to defend.
Because the duty to defend is broader than the duty to indemnify, if I understand your
Correct.
argument. I did not understand that. And is that somewhere in your briefs that I can find that
Yes,
argument that you have to read?
I characterized it as a breach of duty to defend. I know that Mr. Shrimp takes issue with that characterization, so I'm going to back away from it.
Well, he's an opponent. I'm going to ask you, are you on all fours with Mr. Silver?
Yes, although Evanston has provided a defense, so he's not in the same shoes as me. I think he lends moral support on that topic, but
Okay.
he doesn't weigh in officially, as I understand. If page 8 of my brief.
Okay, now I have to find your brief. Let's see, page 8.
I'm sorry, page 7 to 8, the last paragraph on page 7. The Court of Appeals reversed, concluding A, there is property damage caused by an occurrence, B, the business risk exclusions do not exclude coverage, and C, Netherlands breached its duty to defend Jeneil. And then going on to page 8, Netherlands does not seek review of the Court of Appeals conclusion that it breached its duty to defend.
So it does have, you read that to say Netherlands, because it didn't seek review, did breach its duty to defend, therefore the damages have to be determined. Is that your point?
Yes, and
Okay.
those would include, for instance, waiving their coverage defenses, providing attorney's fees and costs, and their limits wouldn't apply, although I understand that the damage here is being claimed is within the limits of the policy.
So if I understand your argument, if you should lose, which you prefer not to do, right? If you should lose, then is a remand.
Correct. Well, I think there has to be remand for further proceedings anyways to address the merits, but I should stress to the court that if this court were to reverse the Court of Appeals decision, that the mandate should not indicate that the Netherlands is dismissed from this case, that the mandate should indicate that the decision is remanded for further proceedings, including proceedings between Netherlands and Jeneil for the circuit court to determine what the consequences are for the Netherlands' failure to defend under the four corners of the complaint.
Was that a finding of the circuit court, that Netherlands failed to defend?
No, it wasn't addressed in the circuit court. The circuit court addressed the coverage issue. If you recall, there was discovery that took place. Let me back up a minute. There was a hearing before the circuit court on the duty to defend without any discovery having taken place. The Insureds argued during that hearing that if there was doubt in the circuit court's mind about how it should rule, that the parties should be permitted the opportunity to take discovery to understand more precisely what the plaintiff's claims were and whether there was, for example, property damage in the form of physical injury or in the form of loss of use. The circuit court permitted that discovery to take place. Once the discovery took place, the insurance companies decided to proceed with their motions for summary judgment, and the circuit court rendered its decision. This is Record 127 is the transcript, on the basis of coverage, indemnity, and that's what the first holding of the Court of Appeals decision touched on.
That's covered in the Court of Appeals brief on the duty to defend as you stated, paragraphs 39 to 41. And the Court of Appeals remanded to the Circuit Court for further proceedings not inconsistent with this opinion. And you think the further proceedings under the Court of Appeals would be to determine damages?
For the breach of the duty to defend, yes.
And you think the Court of Appeals can make a decision that there was a breach of the duty to defend without the Circuit Court having made an underlying findings to support that?
Yes, it's a conclusion of law. And the conclusion was rendered based on the interpretation of the policy, and it was concluded based on summary judgment. Those are both de novo review. And if you look at footnote 8 of the Court of Appeals decision, it says we don't address the consequences of the failure to defend, which suggests pretty starkly that the Circuit Court will need to do that.
But if you win, do you get more damages than the violation of the duty to defend?
Yes, potentially. We can seek, as I said, attorney's fees and costs for breach of the duty to defend if the Circuit Court determines that there was a breach, waiver of the policy limits, and potential waiver of any coverage. But if the court affirms there won't be any coverage defense to waive.
You know, counsel, no one else seems to be looking at the red light, so I'm going to give you an opportunity to help me out.
Sure.
And it has to do with the questions that I was asking you before. I'm looking at response number 5.
Yes.
And response number 5 includes, and that's at your supplemental appendix at page 52, it includes a breakdown of tooling, dyes, and other costs, and that's repeated 3 times. And there are figures associated with it, and then further in the column, exhibit F, G, and H. I'm having a little trouble locating. I see one invoice attached to F. It's the first sheet where it's an invoice for $375. It simply indicates CVS Fem-High probiotic chewable print plates. Can you tell me where it is in the record where it's indicated that these, what are labeled in your response as costs, which when I read or hear the word costs, I think of a price that had to be paid for a good or service. Can you tell me where it indicates that physical damage was caused to the tooling and/or die cutting equipment during this process?
Yes, Justice Gableman, and I'll direct your attention to, and this is on 052, which I think we're looking at the same
It's on
page.
what?
Number 5. Yeah. The question is, in addition to the tableting process identified, described above, identify and describe all other tangible property that has been physically injured as a result of the events described in the amended complaint. And then the response to number 5 is destruction of store and warehouse inventory of the probiotic, cartons, inserts, and shippers specific to the chewable probiotic, tooling and dyes, etc.
In fact, question number 5, you didn't read the end of it, including but not limited to the following: cartons, packaging, bulk fillers, tools, dyes. So question 5 asks specifically for those, and then the response addresses
Correct.
that.
Okay, so you're saying that means that there's a question of fact. There's a question of fact, are you saying? Or are you representing that as truth?
I'm saying there's no question of fact that is true. This is the undisputed record evidence that there was physical injury to the inventory, the tooling, the dyes, the cartons, the shippers.
But the record also seems to indicate to me, when read together, that no destruction of the packaging occurred until it was purposely destroyed as a part and parcel of pulling the product from the stream of commerce.
I think that's a fair inference to make, but I don't think that that is in the record. But again, this is
There was no complaint about any damage to the packaging from the retailer, right?
Well, I disagree with
Or
that,
am I
Justice.
wrong? Did the retailer contact anyone? Does the record disclose the retailer contacted anyone and say, hey, I can't sell this product because the packaging there's something wrong with the packaging? That wasn't the complaint, was it?
There's nothing of that nature in the record.
Okay.
But
The complaint was solely, as I understand it, that the product contained the incorrect bacteria.
That's true. And the record does not support the notion that Pharmacal made a business decision to scrap otherwise salvageable material.
Well,
The record does not support that. The record is that this material incurred.
Pharmacal is ordering plates that say CVS Femme High, or whatever it was called. They're not, chances are after this, they're not going to have much use for that anyhow.
That may be true, but it was incumbent upon the insurance companies to elicit that kind of information,
Okay,
and they
then
didn't do so.
Thank you for helping me to understand your position.
Sure, thank you.
Could you please clarify one of your first statements for me? The way I understood it, in the cross claims, Nebraska sued Jeneil in negligence? Or at least
Yes.
partly in negligence?
Yes, Justice Prosser. If you look at Record 21, and if you don't have it, I'll read it to you. It's pages 10 to 11. The first allegation realleges and incorporates all the allegations in the complaint. The second allegation is, if plaintiff or plaintiff's assignee sustained any injuries or damages as a result of any of the events referred to in the amended complaint, such injuries and damages as may have been sustained were caused directly and proximately by negligence and other wrongful conduct on the part of defendant Jeneil Biotech.
Now, and that has sustained all the motions here. It's still
Correct. That's still a live claim in this case.
How is that consistent with the economic loss doctrine?
Well, we elected not to move to dismiss that claim.
Well, wasn't that a little self-serving?
I don't know that I would say that. I mean, the court rendered a decision to dismiss certain claims, and that hasn't been fully vetted yet because, of course, the Court of Appeals could conclude that the circuit court was wrong when it dismissed those claims. And if they're reinstated, then it won't matter necessarily that there's a claim for negligence remaining because there'll be a claim for misrepresentation remaining against Jeneil as well. I mean, be it as it may, there's a claim for negligence against Jeneil. And again, CGL policies are designed to provide coverage for tort liability. That's the claim against Jeneil in this case. So I would conclude by respectfully requesting that the court affirm the Court of Appeals decision. Thank you.
Which includes a remand.
I beg your pardon?
Which includes a remand.
Yeah,
to the
because
trial court.
as I said, the merits will have to be determined anyways.
May it please the court, I'm attorney Patrick Silver, and I represent the defendant appellant, Nebraska Cultures of California, Inc. I think that a lot of the issues in the cases here have been thoroughly briefed, and the court can refer to those briefs in the fullness of time and in the luxury of reflecting in chambers. I'd like to take a giant step back from this and look at what this case is ultimately about from the point of view of the insured. There was a contract between two private entities. It was an insurance contract. There's a dispute as to what the rights and duties under that contract are. Now, the first thing that a court does when there's a dispute under a written contract is that it refers to the actual language of the agreement. You'll note that in the insurance company's briefing, they don't do that. Instead, they launch into a 20-page discussion of Wausau Tile, the integrated systems analysis, the economic loss doctrine, and all other exotic creations of law and insurance companies challenging coverage. Our insurance contract is controlled by California law, not Wisconsin law. Now, there may very well be some similarities in insurance coverage analysis under the law of California and under the law of Wisconsin. But that does not mean that in every instance the law of Wisconsin controls, and it certainly doesn't mean that Wausau Tile is binding on a California court. So when you look at this case, you have to ask the question, what is the law of California? What case law would bind a California court applying California law? What cases are merely persuasive? And how do all of the cases relied upon the parties comport with that basic premise for the analysis?
Counselor, do you believe that the property has been physically injured or destroyed?
Yes, Your Honor.
Okay, I'm most interested in the exclusions, I have to tell you, given past case law. And I'm looking at your policy, and I'm on page 40, and I can't tell you which appendix I have, but it deals with B with respect to exclusions, property damage, and personal injury, and it says what it doesn't apply to. And I'm looking at B3, and it says it doesn't apply to any claim based upon or arising out of loss of use of tangible property, which has not been physically injured or destroyed, resulting from, and then subsection 2, a defect, deficiency, inadequacy, or dangerous condition of the product. Can you tell me why you think I shouldn't apply that to the circumstances here and say there's no coverage?
Two reasons, Your Honor. First is because there is physical injury to tangible property. This exclusion applies based upon loss of use of tangible property not physically injured or destroyed. Here there is property physically injured or destroyed.
So you still have to get back into whether I look at this as an integrated system or not, correct?
I don't think you do, Your Honor.
Okay.
But I'll come back to that because I want to give you the second reason. Yep. If you go down into the exclusion, you'll see that there's a clause after sub 2, which says, provided, however, this exclusion does not apply to loss of use of other tangible property resulting from the sudden and accidental physical injury to or destruction of the named insured's products or works performed by or on behalf of. So in other words, this exclusion says that if there's sudden or accidental injury to something else, then the exclusion doesn't apply. And that's perfectly consistent with business risk exclusions in CGL policies.
What's the sudden or accidental injury?
Well, here it would be the alteration of the other ingredients, the destruction of the other ingredients which happened at the time of the tableting process.
Okay.
I would like to stress that when you begin with the policy language, you look to, among other things, the very first page of the policy, which is, in effect, the declarations. And that tells you some very important information, including who the insured is, the limits of liability, the coverages that are made available, and that includes coverage for property damage liability. If you read down further, you'll notice on the first page of the declarations, there's a section which is entitled Item 6, Specified Products goods, operations, and premises covered, microbial food supplements distributed by the insured, all related premises and operations of the insured.
Just a moment. What's your citation to what you're reading?
Oh, it would be page 41 of the underlying policy. Sorry, just give me a moment, Your Honor. I'll find the exact.
I think it's 75-41 record number, maybe, if that's what I'm following in. It's specified products, goods, operations, and premises covered. Is that what you're referring to?
Yes, ma'am, thank you.
Okay, 75-41.
7541. Now, that language is meaningful in the context of the policy's insuring agreement, which is where you have the language which is referred to as language that provides a coverage grant. And that would be in 7554. And the reason I'm going into such detail is that this is not a standard insurance services offices or ISO form policy. And therefore, I don't want the court to jump to conclusions by assuming that just because CGL policies generally provide coverage for property damage caused by an occurrence, I don't want the court to lose sight of the fact that this particular policy actually points back to the declarations page. At record 75, page 54, it says insuring agreements. I'm not going to read the entire provision. The operative language is as follows. Coverage A, bodily injury and property damage liability. The company shall pay on behalf of the insured all sums in excess of the deductible amount stated in item 5 of the declarations, et cetera, et cetera.
How do you compare that with an exclusion, A1A, which includes the product's hazard or completed operations hazard as defined in your policy?
Sorry, Your Honor, which exclusion are you referring to?
It's exclusion, capital letter A, Arabic 1, sub, looks like an item, but I'm not sure, and then it's a parent A parent, so it's under big A, you got a little a, and it says, with respect to all coverages, this policy does not apply to the product's hazard or completed operations hazard. And my question to you is, how do you get coverage given that provision and your definition of completed operations hazard, which is in definition sub H?
Well, you have to have some kind of physical injury to tangible property or loss of use, has to be caused by an occurrence. Now, the exclusion you're pointing to is a pollution exclusion.
Just says the exclusions. You say it's only pollutants. Okay, that's a good answer.
What record number are you referring to?
That's also 75, page 58, Your Honor.
Okay, good, thank you.
Yeah, so that exclusion is a pollution exclusion that applies to completed operations.
Thanks.
Now, getting back to the insuring agreement, as I was reading, it says that the policy applies, and if you read down to, this is on 7554, capital A, sub 2, such bodily injury or property damage arising out of only those products, goods, operations, premises specified in item 6 of the declarations. Well, item 6 of the declarations, as I've just mentioned, says that it applies to microbial food supplements distributed by the insured, and all related premises and operations of the insured.
Okay, well, it was distributed by the insured. It was withdrawn from the market, right?
It was withdrawn by some downstream buyer.
Okay, so I want to, and maybe that's your answer, but I want to also look at the exclusion A5, which is any claim for damages. If products, work or property are withdrawn from the market or use because of any known or suspected defect, how come that doesn't apply?
That exclusion does apply. It's called a sistership exclusion. It applies to other products that have a suspected problem and prior to the discovery of any injury or even loss of use are withdrawn from the market. This exclusion has an interesting history. It's called the Sistership exclusion because it was initially drafted to meet a particular incident that occurred in the aircraft manufacturing industry, where a manufacturer, say Boeing, produces a line of aircraft. There's some incident that produces damage to an aircraft, and the manufacturer withdraws all other models of the same line of aircraft because of this actual incident that occurred to one of its products.
So you're saying this doesn't apply to withdrawal of the tablet?
It doesn't apply here at all because all of the tablets contain the damaged ingredients of nutritional manufacturing or Pharmacal. This exclusion only applies to products that are not damaged but which are withdrawn from the market because they have this suspected problem that they don't want to cause injury or liability to others. But even if the exclusion applied, it would only apply to, say, the costs of the recall. It wouldn't apply to the actual damage to the other ingredients themselves.
And that's what the Court of Appeals found here, as I recall, that it applied to the expenses of the recall itself.
I believe that's correct, Your Honor.
If I'm wrong, you don't know.
The Court of Appeals decision speaks for itself, and frankly, Your Honor, I don't have that part of the decision committed to memory.
Is there anything about the Court of Appeals decision you don't like?
Not much.
You answer that even though you're not committed to memory?
By and large, I like everything about the Court of Appeals decision. I think there are things that I would have added, and I'm happy to provide that. Among other things, we have to remember that the economic loss doctrine and integrated systems analysis is completely separate as an analytical tool from the fundamental issue of insurance coverage. My co-counsel made this point in the context of the paired examples of Linden versus Cascade and Jacob versus Russo. Now, it's interesting to note, Linden is a Supreme Court decision, and in that case, the Supreme Court expressly rejected the homeowner's efforts to point to coverage under an insurance policy as a basis for a determination that the economic loss doctrine doesn't apply. The insurance companies here are making the mirror image argument. They're saying that because there is an integrated system and therefore no other property, that therefore there isn't insurance coverage. So in some respects, analytically, the issue before this court has already been addressed in Linden.
Counselor, I want to look again at another exclusion. They're really bugging me, as you can see. And this is exclusion A9, starts out any claim based upon or arising out of property damage to, and then I want to go to Roman numeral 6. It says to work performed by the insured arising out of such work or any portion thereof or out of materials, parts, or equipment furnished in connection with and respect to the completed work. Okay? So tell me why that doesn't apply.
All right, I will, Your Honor, thank you. It's exclusion A9 on page 75-60.
Thank you.
In effect, this property does not apply to any claim based upon or arising out of property damage to property owned, occupied, or rented to the insured. Obviously, that's not at issue. Property loaned to the insured, not at issue. Personal property in the care, custody, or control of the insured, it's not at issue.
We're not talking about that. I just want to look at Roman numeral 6.
All right, 6. Sorry. Does not apply to work performed by the insured arising out of such work or any portion thereof, or out of such materials, parts, or equipment furnished in connection therewith. Well, that exclusion simply applies to the work by the insured in connection with its own product. It doesn't talk about other work or other products that become a part of the insured's product. I mean, think about this.
the insured's product, at one moment, I'd have to think that this means that the bacteria was the sole insured's product. But earlier on, you're telling me, no, they made this pill and you've damaged the other ingredients to the pill by sticking the wrong bacteria in there, right? So
no,
the product.
Sorry, Your Honor. Maybe I misspoke.
No, I probably misheard
Okay.
you, so straighten me out. That's
Yeah,
fine.
let's make sure we understand what's going on here.
That'd be good,
The insured sold an ingredient, this bacterial culture.
right?
The buyer took that ingredient, put its own ingredients into a big vat, mixed them together, and those other ingredients that were mixed with the insured's bacterial culture
Right.
became damaged.
Okay,
Now, this exclusion would apply, if at all, to the insured's own work or product. So if Nebraska was trying to get indemnification for its liability to the buyer for its own defective bacterial culture, the insurance companies wouldn't pay for that. That is the paradigmatic example of faulty workmanship. But if there is damage to something else, then that is something that is covered. Think of it in the
so
context...
the word parts in here doesn't have anything to do with what we're talking about?
It talks about materials,
Parts,
or equipment furnished in connection therewith, meaning furnished by the insured, not furnished by anybody.
no, well, didn't they furnish the bacteria? Wasn't that a material they furnished?
They furnished the bacteria, but they did not furnish the other ingredients.
Right.
And it's the liability for the damage to the other ingredients that we seek insurance coverage for, not coverage for our own.
Well, didn't it arise out of the bad material they gave when this was put together, when this tablet was produced? I'm saying the wrong bacteria is a bad material, so
Yeah.
that's what I'm,
The damage to the other ingredients did arise out of
out of the material they provided,
out of
correct?
the material we provided.
Okay,
If the suggestion is that therefore there's no coverage for the property damage to some other component because that damage arises out of our ingredient, then the policy would never apply. Because any liability we would have under such circumstances invariably must ultimately arise out of something we did, and therefore there would never be coverage, which would be illusory. This kind of exclusion, you can see it, how irrational that result would be in the context of a new home construction case.
Counsel?
Yeah.
Before you get into your new home construction case, I want you to give me, is it still 7560 you're talking about in terms of where this wording is located?
Yes, Your Honor, 7560 to 61.
and I don't know if this helps you, if you can find it, I got it out of the appendix.
Oh, you
so-
have 4057.
Maybe out of a different appendix, but if you find the language that I have, then you'll find it.
Well, that's my problem. What's your number that you have, record number?
75-60 and 61, I believe.
Okay, and what number are you referring to here? You started with 9, but then you were corrected that we're talking about 6. But 6 on 7560 doesn't have the wording that I'm hearing you two discuss.
I think it's page 9 of the policy, Ann, if you could find page 9
Well,
of the
that's
policy.
7561 in the record, if it's page 9 of the policy.
But there's no number 6 there,
Well,
so,
it's a Roman numeral 6 at the top, on page 9.
okay.
Sorry.
So 7561, Roman numeral 6
Yeah.
is what you're
Yep,
talking
yep,
about.
thank you.
Okay. Now, is that really Roman numeral 6 at the top, that one?
Yeah, that's Roman numeral 6 of exclusion 9.
Got it, now I understand. Yeah.
And just for the record, I think we all know, the insurance company did not rely upon this exclusion. I believe that this analysis and Q&A is for purposes of interrogating the scope of the kind of coverages provided by the policy and excluded by
that's
that.
co-
And I think that's a healthy exercise.
That's correct. I mean, I've highlighted all the ones that are claimed, and I just didn't have this one highlighted. That was, so it's your understanding that this was not raised or briefed or argued, but good for hypothetical discussion.
Absolutely, Your Honor. I think that is, that's within the scope of how you analyze any written contract. You can look to the contract as a whole in order to ascertain what the particular provisions mean and don't mean.
Are you done with
No,
that?
he was on the new house, and I interrupted
Okay.
you. If you wanted to go
New
there,
hou-
maybe you
tell us
forgot
about your new house.
Well, if the insured is a subcontractor working on a house and the insured's own work fails, but as a result of that failure, there's some damage to another part of the house. Say that I'm a subcontractor and I'm doing only the stucco work, but as a result of my defective stucco work, water leaks in and causes moisture damage to OSB and interior flooring. I would not be covered for my liability to the owner of the house for my own defective stucco workmanship, but I would be entitled to coverage for the damage to the other parts of the property. That's exactly what was at issue in Jacob versus Russo. Now, naturally, the house is an integrated system. That is the result of the Linden case. But the fact that the work becomes integrated into some other system by virtue of the economic loss doctrine analysis doesn't mean that the insured subcontractor is not covered for the damage to the other part of the property.
Aren't you just saying that insurance law is one thing, economic loss is another, and the twain sometimes or many times does not meet, and it doesn't meet here? Is that a
I agree with that, and under California law, it never meets. There's no case that's been cited to show that California courts apply any kind of economic loss doctrine or integrated systems analysis for purposes of establishing insurance coverage.
Your red light's been on and has been on a long time, but I'd like to go back to the question I asked you, which got interrupted by exclusions, namely, what would, you responded you'd add things to the Court of Appeals decision, and you added the concept that economic loss and integration are different concepts than insurance policy. All right, anything else you'd add?
I would add that there is not a single case that's been cited by any party that would show no coverage under the circumstances here, whereas there are ample cases that have been cited to show that a so-called non-conforming product resulting in damage to other property is covered under a liability policy. The only two cases cited by the insurers that oppose that position are the F&H case, which is the defective or the inadequate steel caps that went on to pylons,
Right.
and also, I believe,
What about that, the Ammond?
yes, that's correct, the Shade case, which had wood splinters and almonds that were supplied for breakfast cereal. Now, in the F&H case, there was no physical injury to tangible property and no loss of use, and therefore, you didn't get your foot in the door under an insuring agreement in the first instance. Here, in contrast, we do have evidence of physical injury to tangible property. Under the Shade case, the argument is, well, there were wood splinters in the product, and it was the wood splinters that caused some sort of damage to the integrated whole. In my judgment, that observation actually is more or less in line with what happened here, which is you've got a non-conforming product that allegedly caused damage to other ingredients.
I have another question for you, if you're done. Why shouldn't I be convinced by Judge Riley's dissent? Why shouldn't I be convinced by Judge Riley's dissent? And he says, you're all wet. Says that this is integrated and no damage to other property, and just takes the other view. What's the matter with his dissent?
I think his dissent misses the point that there is evidence of damage to other property, and that in itself is something that's covered under the insuring agreement, and that there is no rule in Wisconsin, and certainly none in California, that would operate to remove coverage in this case. In fact, I don't recall that the dissent made any reference to the operation of California law.
Well, the majority didn't make much either. In fact, I don't think any of the briefs make much of that. But in fact, the implication I got from all of this is that they look pretty much alike, and if you're going to push on Warsaw, then California's not going to take it. That's a simplified Abrahamson view, which maybe is too simplified.
Your Honor, the other problem with the dissent analysis in this case is that it relies principally, if not exclusively, on the existence of a misrepresentation claim.
Well, that's what bothered me. And if I understand it correctly, that misrepresentation claim has been dismissed.
That is correct, Your Honor.
And so, in paragraph 44, he says, the majority misses the simple question presented, does CGL, that's the general liability policy, provide covers for claims based on misrepresentation? And then he says, under Stewart and under Everson, this court said no, and that he's bound to follow the state Supreme Court. That's Cook, of course. And so then he moves on to the four corners of the complaint, etc. But he always seems to come back to Stewart too, and Everson, and false assertions and degree of volition. So that's how I read this.
Your Honor, that's how I read it as well. There is no claim for misrepresentation. Many lawsuits involving construction defects, defective products, are based on a whole host of legal theories that might include misrepresentation, but that does not drive insurance coverage. That's the law of Wisconsin, and it's the law of California. You don't base an insurance coverage analysis on legal theories. If you did, the insureds would be held to a very unreasonable standard. They're businessmen, they're not lawyers, and they shouldn't be bound by a policy that is written by an insurance company with the idea that, well, there are some cases in other courts that have held so-and-so. And finally, with respect to the issue of whether there was a volitional act, I think that the court understands that there are many actions which are the subject to negligence claims which entail some degree of volition. In fact, there probably can count on one or two hands the number of acts that can be created by a human that do not entail some volitional conduct.
Thank you, Counselor.
All right, thank you, Your Honor.
Rebuttal, please.
Thank you. Several points I'd like to make. First of all, going back to this duty to defend, which sort of makes my blood boil, because in this case, what the Court of Appeals said that there was an initial duty to defend. That's what they found. And they said, we'll address those consequences later. But to make it clear, the reason Netherlands did not provide a defense is because they followed what this court had told us time and time again to do, was seek a stay. And that's what's happened in this case. Is the merits case has been stayed. There can be no breach of the defense obligation, and there's no reason to remand the case on that issue.
Well, what did the Court of Appeals remand it for?
I'm not, the way that came
merits
up.
of the claim.
Pardon me?
The merits of the claim haven't been determined.
Yeah, the merits of the claim have never been decided. It's been remanded for that determination.
What's the claim again, that the merits have to be decided?
I think that's part of it. When the court was addressing the duty to defend, first of all, the breach was never raised at the circuit court, so the Court of Appeals, especially on the motion for clarification that took place, withdrew the language saying there was a breach of the defense obligation, just saying we find there was an initial duty to defend, and will remand for the court for the impact of that decision. And that's as far as it got. It never considered the fact that there had been a stay in bifurcation of the merits case. And under the circumstance, I don't think there's any reason to remand on that issue. Two things. In terms of Jeneil Biotech's argument that there's a tort claim because of this claim for contribution. I think that's a fiction to a large extent. The trial court was very clear that the economic loss doctrine applied and that therefore only the contract claims existed. The fact that there's this hanging claim for contribution really doesn't make a difference at this stage or for the purposes of the insurance coverage.
Well, should it? That's the question. I guess, we've got to decide. A classic case of a third-party claim for contribution and/or indemnification based on negligence, I mean, generally speaking, would be a slam dunk for at least an initial grant of coverage. Not nuanced like this with economic loss doctrine and stuff, but a general claim for contribution and/or indemnification based on negligence would be covered.
No, I disagree.
Okay,
And the reason
fine.
I'll explain why, I think one thing that American Girl did teach is it's not the label that's placed on the cause of action that either creates or denies coverage. It's the facts pled in the case. Number one, so the fact that there's a claim for contribution doesn't mean much in terms of coverage. And number two, under the insurance agreement, we still have to have property damage caused by an occurrence.
Okay, let me start with number one. It is the facts pled. I don't have the third-party claim in front of me, but I assume since the prayer of the complaint is for indemnification or contribution, I assume that the averments in the complaint are that there was negligence.
Well, the initial complaint, if you go back to the initial complaint, it included claims for negligence as well as
Yeah, I'm just talking about the cross-claim. I mean,
Yeah.
does the cross-claim contain an averment of negligence?
I believe because it was part of the original pleadings, it included that. But negligence is not what's controlling, is what the facts were. And you still have to look as to whether there's property damage caused by an occurrence in this case. And because we moved for coverage and looked at the facts, we're looking at actual coverage as opposed to a defense obligation at this stage of the proceeding.
The reason I asked the question is that you said there were two things. Number one, you look at the facts in the complaint, and number two, that there was no property damage in this case. I'm focusing on your number one, facts in the complaint. And my guess is, without having the counterclaim in front of me, that the facts alleged in the counterclaim include negligence. That's all I'm saying. I mean, you raised it in saying there's two reasons, and I'm saying, I bet you that first one doesn't fly.
And what the, if I recall correctly, is what the cross-claim for contribution or indemnification states is it re-alleges the allegations in the complaint and incorporates, except as limited or denied by their answers. It's a standard, pretty standard cross-claim. I don't think that cross-claim creates coverage under the facts of this case.
So if you have any indemnification or contribution obligation, it's contractual here, right?
That's correct. There
Period.
could be
Yeah.
indemnification claims contractually on the part of the insured. The second, I think, fiction that we talked about is this whole allegation of physical injury. And it's true that the interrogatory uses the stark, the terms they wanted to use, that is, yes, there was physical injury to tangible property. But I think, and counsel admitted the reasonable inference, and I think it's the only inference, is that the packaging and dyes were damaged when they were either destroyed or discarded after they discovered the problem with the probiotic tablets. That's really the only inference you can gather from the allegations in this case. With respect to the impaired property exclusion, which we believe on its face applies, counsel argued that the sudden and accidental destruction of property exception to that exclusion would apply. But sudden and accidental, going back to the pollution days, the just decision, means unintended and unexpected. In this case, the destruction of that property, both with respect to the destruction of the tablets and the packaging after the problem was discovered, was intentional. It was not unintended or unexpected. And going back again to the physical injury that they claim to the ingredients of the tablets, we have to acknowledge that the formulation of the tablet was all a volitional act. That was not an accidental act. So any alteration of the ingredients was purely volitional.
Let me just ask for clarification. What are the exclusions that you are relying on in your policy?
With respect to the Netherlands Insurance Company, we are relying upon the impaired property exclusion, which applies to impaired property or property not physically injured, and that only applies under circumstances where, if the court defines there's only a loss of use claim. But
And that's M, is that
That's
correct?
exclusion M, that's
Okay.
correct.
What other exclusion, if any, are you relying on?
That's the only exclusion Netherlands is relying upon before this court. We raised the recall exclusion, which is exclusion N, I believe, and we believe the Court of Appeals was correct in its application of that exclusion to the facts of this case.
Okay. Those are the only two exclusions that Netherlands is relying on.
Yes,
Is that
and-
correct? Is it your understanding that Evanston is also relying on the damage to your product exclusion?
Yes.
Okay. Any other exclusions being relied on by either of the insurance companies in this case?
Not to my knowledge from Netherlands' standpoint, and I believe that's accurate with respect to Evanston.
The one I was pointing out before, which is exclusion 9, subsection 6, is in the Evanston policy. It's not in the Netherlands policy.
The one you were talking about, yeah. And I was just corrected, Evanston has also relied upon their sistership.
That's, but you,
I'm sorry, what?
the sistership,
Sistership.
which is the equivalent of your recall N, is that correct?
That's correct. The wording is different, but it's,
Substance is the same. So I just want to get this down.
that's
So
correct.
you, Netherlands, is relying on your M, which is damage to impaired property, and you discussed N as a Nancy, which is the recall of products. Am I correct?
That's
For
correct, Your Honor.
Netherlands. And it's your understanding that Evanston is relying on B3, which is impaired property exclusion. That's the same as your M in substance, is that correct?
that's correct.
They are also relying on B4, which I understand is your product exclusion, and B5, which is the sistership exclusion that is the same as your N recall.
That's correct.
Anything else that comes to your understanding of exclusions that are being claimed by the insurance companies here?
No, Your Honor.
Okay, thank you.
I think one last point. When we talk about the construction defect cases and comparing them, all of those cases had an intervening event which resulted in physical injury to tangible property. In Jacob versus Russo, it was the water damage. Even American Girl, it was the buckling of the building. In our instance, all we have is the tablet that's been manufactured with the non-conforming product. If you asked a layperson to look at that tablet and ask, has it been physically injured or destroyed, the answer would be no, because it hasn't been. It doesn't meet that policy definition. And for that reason, we asked the court to reverse the Court of Appeals and find that the insurer's policies do not provide coverage either under the insuring agreement or because the policy exclusions apply, and the case should be remanded to the trial court for a determination of the case on the merits.
Remanded to the trial court for what? I'm sorry, I didn't.
For a determination of the merits of the case.
Thank you. Thank you.
The Wisconsin Insurance Alliance submitted a brief, an amicus brief, and their position is that Pharmacal has alleged faulty workmanship and the failure of Nebraska and Jeneil to adequately perform their job of selecting and providing the correct ingredient And under Wisconsin law, these allegations are not an occurrence. And there's no bodily injury or property damage, but it's not an occurrence. I assume you agree with that analysis.
Yes, we do.
And on their other analysis as to whether it's property damage, I'm assuming that you agree with that.
That's correct, Your Honor.
All right. You know, we spent a long time over the red light for you and your co-counsel during your first argument. I didn't really keep tabs on how much, and then spent a lot of time after the red lights went on for opposing counsel. And I have to tell you that frequently happens when a counsel don't take their full 30 minutes, you know, one person. As soon as you divide it up, the minutes run very much more quickly. But I don't want you to leave thinking that you didn't get an adequate time to express your views. So I'm happy to ask you any question you want to be asked, and you may answer it.
What a deal.
Your Honor, I think all counsel were very pleased with the time allotted to us. We are fully able to explain our positions, and if not, our briefs, I think, pick up where we left off.
Thank you very much for a good argument.
Thank you.
This concludes the argument in this very interesting case. You know, just when you think you've heard every argument that could go for insurance coverage, you all bring us something totally different, and we have to look back at all of these cases. So thank you all for wonderful briefs, the amicus for a fine brief as well. They were very, very helpful, and it was a good argument too. So thank you so much, and we are adjourned. The court will meet